Did you know that in 580, and in the blossoming kingdoms of the Franks, a woman's life was meticulously dictated by laws that placed her firmly under male control? Could she own land, speak for herself in court, or even choose her own husband? Brace yourself, because the answers might just shock you. Number 8. Legal minority and the enduring mundium. Imagine living in a world where, no matter how old you got, no matter how much wisdom you accumulated, you were never truly considered an independent adult in the eyes of the law. This wasn't some far-off fantasy for Frankish women in 580 AD. It was their everyday reality, governed by a pervasive legal concept known as mundium. The mundium was essentially a form of perpetual guardianship, a legal authority held by a man over a woman. From the moment she drew her first breath until the day she passed away, a woman was always, without exception, under the mundium of a male relative. This wasn't just a quaint custom. It was the bedrock of female legal subordination in Frankish society, a legal chain that bound her autonomy in almost every sphere of life. The concept of mundium wasn't unique to the Franks, but it was particularly entrenched and powerful within their Germanic legal traditions, distinct from some aspects of Roman law which, while patriarchal, offered different avenues for female independence. Particularly for widows, for the Franks the mundium was less about age and more about gender. A girl might be a child under her father's mundium. When she became a woman, perhaps even a mature woman with children of her own, she merely transitioned from her father's mundium to her husband's. If her husband died, her mundium would typically pass to her adult sons, her brothers, or even other close male relatives. This meant that a woman, regardless of her intelligence, her capabilities, or her personal desires, could not, by herself, perform any significant legal act. She could not initiate a lawsuit, buy or sell property of any significant value, make a will, or even enter into a binding contract without the explicit consent and oversight of her mundium holder. Consider a young woman, perhaps named Bertha, living in a Frankish village in 580. Let's say Bertha inherited a small plot of land from her deceased mother, a rare and somewhat complicated occurrence in itself, as we will explore later. Even with this inheritance, Bertha could not simply decide to sell that land to a neighboring farmer. She would have to go to her father, or if he was gone, her oldest brother, and seek his approval. He, as her mundium holder, would then be the one to legally oversee the transaction, his presence and permission validating the sale. It wasn't Bertha's signature that truly mattered in the eyes of the law. It was the authority of her male guardian. This system fundamentally stripped women of their agency, reducing them to perpetual minors in legal terms, always requiring a male hand to guide their actions in the public and economic spheres. The weight of mundium also extended to a woman's personal safety and her value within society. When a woman was harmed, whether through injury, abduction, or even death, the legal recompense, known as the wergild, was not paid directly to her. Instead, it was paid to her mundium holder. This wasn't merely a procedural detail, it underscored the underlying principle that a woman's value was often viewed in terms of the loss suffered by her male guardian. Her honor was tied to his honor, and the violation of her person was, in a very real sense, a violation of his proprietary rights over her. For example, the Lex Salica, one of the most important Frankish legal codes, specified varying wergilds for different injuries to women. But these payments consistently went to the man who held her mundium. This legal framework reinforced the idea that women were not independent legal subjects, but rather objects of protection and control, their worth measured by the compensation due to their male kin. What happened if a woman found herself without a male mundium holder? This was a precarious situation. A widow without adult sons, or a woman whose male relatives had all passed away, could find herself in a legal limbo. In such cases, the law often stipulated that a male relative, no matter how distant, should step forward to assume the mundium. In desperate circumstances, if no family member was willing or able, the king or a local lord might appoint a guardian, or the woman herself might be permitted to choose a male protector, though this was still an act of male authority, not female independence. It was a testament to the absolute necessity of this male guardianship that even in the absence of a direct family member, the legal system would still impose a male protector, rather than allow a woman to operate as a truly free agent. This constant legal need for a male overlord highlights the deep-seated belief in Frankish society that a woman, by her very nature, required male guidance and protection to navigate the complexities of life and law. Her identity, her rights, and her very existence in the public sphere were inextricably tied to the man who held her mundium. Number 7. Limited property, rights, and the male inheritance, privilege. Imagine working tirelessly, contributing to your family's prosperity, yet knowing that the fruits of that labor, and even the land you walk on, might never truly be yours to command. For Frankish women in 580, property rights were a maze of limitations, a stark reflection of their subordinate status. While it's a common misconception that women owned absolutely nothing, the reality was far more nuanced and ultimately far more restrictive than for their male counterparts. The ability to own, inherit, and control property independently was severely curtailed, often contingent on male oversight or inheritance patterns that heavily favored men, particularly in the realm of land. At the heart of these limitations lay the crucial difference between movable property and immovable property, especially land. Frankish legal codes, particularly the Lex Salica, made a clear distinction. While a woman might possess personal items, her clothing, jewelry, household tools, perhaps even a few livestock that she had personally managed, her access to and control over land, the most valuable form of wealth in an agrarian society, was severely restricted. The Salic law, which applied to the Salian Franks and influenced wider Frankish society, famously stipulated that no inheritance of land shall come to a woman. This single provision was a monumental barrier to female economic independence. It meant that a daughter could not inherit ancestral land if there were any male heirs, no matter how distant. The land, the very foundation of family wealth and status, was reserved for the sons, the brothers, the nephews, or any other male relative down the line. Consider a Frankish family with several daughters but no sons. In a society where primogeniture, the right of the firstborn son to inherit, was becoming increasingly important, this family faced a conundrum. Upon the father's death, his land would not pass to his daughters. Instead, it would revert to his brothers or his male cousins, or even more distant male kin. The daughters might receive movable property, perhaps some livestock or household goods, as part of their portion, but the land itself, the source of power, prestige, and ongoing sustenance, would bypass them entirely. This legal principle ensured that control over the most valuable asset in the Frankish kingdoms remained firmly in male hands, reinforcing the patriarchal structure of society and preventing women from accumulating independent wealth and influence based on land ownership. Marriage, a central institution in Frankish life, further complicated a woman's property rights. Upon marriage, her existing property, particularly any movable wealth, often merged with that of her husband, coming under his mundium and control. The dowry, a gift from the bride's family to the groom, was not intended to be the bride's independent property. It was often a contribution to the new household, managed by the husband, and sometimes even a sort of prepayment of the wife's inheritance from her own family, reducing what she might later claim. The Morgengabe, or mourning gift, given by the groom to his bride the morning after the wedding night, was perhaps the closest a woman came to having independent property within marriage. This gift, often consisting of movable goods or a specified portion of land's usufruct, the right to use and profit from it, but not own it outright, was intended for her support and could sometimes be held independently, especially if she became a widow. However, even the Morgengabe was a gift, a transfer of property from the husband, rather than something a woman generated or inherited independently. The limitations extended beyond inheritance and marriage to the ability to control and dispose of any property a woman might possess. As established with the mundium, any significant transaction, whether buying, selling, or gifting, required the consent and legal oversight of her male guardian. A woman could not simply write a will and bequeath her possessions freely. Her will would need to be approved and validated by her mundium holder. While some rare instances show elite women making substantial grants to churches or monasteries, these acts almost invariably involve the active participation and consent of their male kin. This meant that even if a woman came into possession of property, perhaps through gifts or specific circumstances, her autonomy over it remained severely restricted, turning her into more of a steward than a true owner. The cumulative effect of these property laws was profound. By limiting women's access to land and their independent control over wealth, Frankish society ensured that women remained economically dependent on men. This dependence was not just a matter of individual financial security. It was a fundamental pillar of their social subordination. Without independent means, a woman's opportunities for self-determination, for wielding influence outside the domestic sphere, or for challenging existing power structures were severely curtailed. Her security and standing were tied to the men in her life, her father, her husband, her sons, rather than to her own accumulated wealth or legal standing, solidifying her position as a protected but perpetually subordinate member of society. Number 6. Marriage as a contract of transfer, not choice. Imagine a momentous day in your life, one that forever alters your path, yet you have little to no say in the matter. For Frankish women in 580, marriage was precisely this, less a union of two individuals based on mutual affection or choice, and more a meticulously arranged contract between two male heads of household, signifying the transfer of a woman's mundium from her father or guardian to her husband. This wasn't a romantic ideal. It was a practical, legal, and economic transaction designed to forge alliances, consolidate wealth, and secure family lineage. The bride's personal desires, if they existed, were largely irrelevant to the grander scheme of family strategy. The process began long before any vows were exchanged, often with elaborate negotiations between the groom's father and the bride's father or guardian. These discussions weren't about the compatibility of the future spouses. They were about the dowry, the dose, the mourning gift, the morgengabe, the bride price, and the precise legal arrangements for the transfer of the woman's mundium. The dowry, as we've discussed, was a significant part of the bride's family's contribution to the marriage, essentially an advance on her inheritance, or a payment to support the new household. The morgengabe, given by the groom, was a symbol of his commitment and a form of support for his bride. These financial considerations were paramount, often outweighing any consideration of individual preference. The concept of traditio, the formal delivery of the bride, vividly illustrates the transactional nature of Frankish marriage. This wasn't just a symbolic walk down an aisle. It was a legal act, often accompanied by witnesses, where the father or guardian formally handed over his daughter to her new husband, thereby transferring his mundium over her. This physical act underscored the fact that the woman was being transferred from one male authority to another, her legal status shifting from under the protection and control of her birth family to that of her husband. Her legal identity was defined by who held her mundium, and marriage was the primary mechanism for this crucial shift. The woman herself was more of a passive participant in this ceremony, an object of transfer rather than an active agent. While some Frankish laws mentioned the importance of a woman's consent to marriage, this was often a formalistic requirement, more about preventing abduction or ensuring legitimacy than acknowledging genuine personal choice. It was usually interpreted as the woman's acquiescence to her family's arrangements, rather than an independent decision to marry a particular man. A woman who outright refused a marriage, arranged by her father or guardian, would face severe social pressure and likely legal repercussions, as her defiance would be seen as a challenge to male authority and a disruption of important family alliances. This legal framing of consent was a far cry from modern notions of individual autonomy in marriage. The purpose of marriage extended beyond individual unions to the perpetuation of the male line and the consolidation of family power. For elite families, marriages were strategic alliances designed to secure political influence, expand territories, and solidify dynastic claims. A powerful king might marry his daughter to a rival's son to forge a peace treaty, or to a loyal noble to reinforce his authority. In these high-stakes arrangements, the woman became a pawn in a larger political game, her personal feelings entirely secondary to the needs of the state or the ruling dynasty. We see examples of this throughout the chronicles of Gregory of Tours, where royal marriages are consistently depicted as tools of political maneuvering rather than unions of affection. Even polygyny, the practice of a man having multiple wives, was not uncommon among the Frankish elite in 580, and particularly for kings and powerful nobles before the church's influence fully solidified monogamy as the sole legitimate form of marriage. For a man, having multiple wives could mean more heirs, more alliances, and more opportunities to expand his lineage. For the women involved, it often meant sharing their husband's attention and resources, and their status might depend heavily on whether their sons survived and flourished. This practice fundamentally undermined any notion of marriage as an exclusive, intimate partnership based on mutual commitment, instead reinforcing its role as a pragmatic tool for male family and political objectives. In essence, marriage for Frankish women in 588 was not a journey into personal partnership, but a carefully orchestrated transition from one male authority to another. It was a public declaration of a new male guardian, a formal contract securing lineage and property, and a vital tool for social and political advancement, all predicated on the woman's subordinate role within the broader patriarchal structure. Her choice was limited to accepting the path laid out for her, embodying her ultimate legal and social powerlessness in this most fundamental of life events. Number 5. Unequal legal standing and testimony in court. Imagine standing in a court of law, accused of a crime or seeking justice, but knowing that your voice carries less weight, your testimony is inherently doubted, and your ability to even initiate legal proceedings is severely restricted. This was the reality for Frankish women in 580, whose legal standing and capacity for testimony in court were profoundly unequal compared to men. This disparity wasn't just a minor inconvenience. It was a fundamental aspect of their legal subordination, reflecting the deep-seated belief that women were inherently less reliable, less rational, and ultimately less capable as independent legal actors. The primary hurdle for any woman seeking justice or defending herself in court was the mundium. As we've seen, a woman could not by herself initiate a lawsuit or act as a legal representative. She always required her mundium holder, her father, husband, or other male guardian, to act on her behalf. This meant that if a woman were wronged, say assaulted or defrauded, she could not simply go to the local assembly or court and present her case. Her grievance would have to be brought forward by her male guardian, who would then represent her interests. This effectively meant that a woman's access to justice was entirely dependent on the willingness and ability of her male protector. If her guardian was unwilling to pursue the case, or if he himself was the perpetrator of the wrong, her avenues for legal recourse were severely limited. Even when a woman was present in court, perhaps as a witness to a crime or an event, her testimony was often regarded with suspicion or given less weight than that of a man. Frankish legal traditions, influenced by Germanic customs, sometimes viewed women as more prone to emotionality or less capable of objective observation. While direct prohibitions against female testimony were not absolute across all legal codes, the general sentiment and procedural practices often rendered their statements less authoritative. For instance, in some cases, the number of female witnesses required to validate a claim might be higher than the number of male witnesses, or their testimony might need to be corroborated by male oaths, effectively diminishing their individual credibility. This implied a fundamental distrust in a woman's independent judgment, reinforcing the idea that she needed male validation even in speaking the truth. Consider the concept of vergild once more. While the wergild for a woman's injury or death was paid to her mundium holder, the specific amount could also reflect her perceived societal value, which was often tied to her reproductive capacity. For instance, the Lex Salica outlined specific wergilds for harming women, and sometimes the wergild for an unmarried woman of childbearing age was quite high, reflecting her potential to produce heirs for a lineage. However, this value was still calculated in terms of her utility to a male-dominated family structure rather than her inherent individual worth. And the legal process to claim this wergild still had to be initiated and pursued by a male guardian, further underscoring her passive role in legal proceedings concerning her own person. Furthermore, women were almost entirely excluded from participating in the formal legal structures of Frankish society. They could not serve as judges, legal advisors, or participate in the malice, the local assembly where legal disputes were heard and judgments made. These roles were exclusively reserved for free men. This exclusion from the very fabric of legal decision-making meant that the laws themselves were created, interpreted, and enforced by men naturally reflecting and reinforcing a male-centric worldview that privileged male authority and interests. Women were subjects of the law, but not participants in its creation or administration. Cumulative effect of these unequal legal standings was a significant power imbalance. A woman's legal rights were not her own. They were mediated through a male guardian. Her voice in court was not her own. It was either presented by a man or subjected to additional scrutiny. This constant requirement for male oversight and validation in legal matters meant that women were fundamentally disempowered in the judicial system. They were not equal players in the pursuit of justice, cementing their subordinate position within the legal framework of Frankish society. Number 4. Unequal divorce and adultery laws. Imagine a world where marital bonds could be severed, but the rules for doing so and the consequences of infidelity were dramatically different, depending on whether you were a husband or a wife. For Frankish women in 580, divorce laws, and especially those concerning adultery, were heavily skewed in favor of men, reflecting the pervasive patriarchal control over women's bodies, their sexuality, and their roles within marriage and family. A man had far more leeway to dissolve a marriage or to escape severe punishment for promiscuity, while a woman faced brutal repercussions for similar transgressions. In Frankish society, particularly in the earlier Merovingian period, divorce was certainly possible, though it was often a more informal process than the Church later desired. While the Church increasingly advocated for indissoluble marriage, older Germanic customs allowed for separation under certain conditions. However, the grounds for divorce were far more accessible to men. A husband could, for example, repudiate his wife for barrenness, for leaving the conjugal home without permission, or for a perceived moral transgression. His decision often held significant weight, and while he might have to return her dowry or provide some form of support, the legal process was often less arduous for him. For a woman, initiating a divorce was an incredibly difficult, almost impossible endeavor. Her primary grounds for separation would typically be severe abuse or neglect, and even then, she would need her mundium holder to represent her case. Furthermore, proving such grounds in a male-dominated court against her husband would be exceptionally challenging. Her lack of independent legal standing meant she could not simply declare her desire for separation. She had to convince her male guardian to pursue the matter on her behalf, potentially alienating her husband and his powerful family. This power imbalance meant that women were largely trapped in unhappy or abusive marriages with very limited avenues for escape. The most glaring disparity in Frankish marital law, however, lay in the treatment of adultery. For women, adultery was considered a grave offense, not just a moral failing, but a serious transgression against her husband's honor and property, particularly because it threatened the legitimacy of heirs. If a woman was found guilty of adultery, the punishments could be brutal and often lethal. Frankish law, and indeed many Germanic codes, sometimes allowed for the husband to kill his adulterous wife and her lover if caught in flagrante delicto, in the act. Even if not summarily executed, an adulterous wife could be severely mutilated, disinherited, forcibly tonsured, shaved bald as a sign of public disgrace, confined to a monastery against her will, or repudiated without the return of her dowry, essentially leaving her destitute and disgraced. The shame and legal consequences were immense, often leading to total social ruin. Contrast this with male adultery or promiscuity. While Christian teachings frowned upon it, Frankish secular law was significantly more lenient, if it even addressed it at all. A husband's sexual activity outside of marriage was generally not considered grounds for divorce by his wife, nor did it carry the same severe legal penalties or social stigma as female adultery. A man could have concubines or engage in extramarital affairs without facing the same legal repercussions that would utterly destroy a woman's life. This double standard unequivocally cemented the control men had over female sexuality and reproduction, while largely allowing men freedom in their own sexual conduct. The focus was on ensuring legitimate heirs and preserving the husband's honor, not on mutual fidelity or the emotional sanctity of the marriage. This vast difference in legal treatment for divorce and adultery served several critical functions in Frankish society. It ensured that women remained strictly controlled within the confines of marriage, their bodies and reproductive capabilities exclusively for the benefit of their husbands and his lineage. It reinforced the idea that female sexual purity was paramount for the stability of the family and inheritance lines. And it provided yet another powerful mechanism through which women were legally subordinated, their autonomy over their own bodies and choices severely curtailed by the very laws governing their most intimate relationship. Number 3. Exclusion from public office and direct political power. Imagine living in a kingdom where the laws that govern your life, the decisions about war and peace, and the administration of justice are all made by one gender, with yours explicitly excluded from any direct participation. For Frankish women in 580, this was the unyielding reality. They were systematically excluded from holding public office, serving in the military, or participating directly in political decision-making. Despite the occasional powerful presence of queens, their influence was typically indirect and often contested, operating within a system that fundamentally recognized men as the sole, legitimate holders of public authority. The very concept of kingship, rex, in the Frankish kingdoms was inherently masculine. A woman could not be a king in her own right, nor could she ascend to a throne based solely on her birthright if there were any male claimants, even distant ones. The idea of female succession to the throne, as it existed in some other cultures, was largely absent in Frankish legal tradition, influenced by Germanic customs that emphasized male leadership in warfare and governance. This fundamental exclusion from the highest office set the precedent for all other public roles. Below the monarch, the entire administrative and military apparatus was exclusively male. Counts who governed the provinces, the dukes who commanded military contingents, the mayor domus, mayor of the palace, who oversaw the royal household and administration, the judges who presided over the malice, local courts, and all the various royal officials. These were all roles held by men. A woman, no matter her noble birth, her education, or her practical intelligence, could not legally hold any of these positions. She could not lead an army, preside over a court, or even collect taxes on behalf of the king. Her sphere of influence was confined to the domestic realm, the household and the private sphere, however grand that household might be. Even the malice, the assembly of free men where legal cases were heard and communal decisions made, was a male-only space. Women were not expected to attend, nor could they participate in the discussions, oaths, or judgments that shaped their communities. This exclusion from local governance meant that women had no formal voice in the very laws that governed their lives, further cementing their passive role as subjects rather than active citizens. The Frankish legal codes, such as the Lex Salica, were crafted by men for a society primarily envisioned through a male lens. However, it is crucial to acknowledge the fascinating paradox of influential queens in this period. Figures like Brunhild and Fredegund, queens who wielded immense power during the tumultuous Merovingian era, might seem to contradict this general exclusion. Indeed, these queens were not mere figureheads. They acted as regents for underage sons, managed vast royal estates, engaged in diplomacy, ordered assassinations, and even commanded armies through their male generals. They were formidable political players whose actions shaped the course of Frankish history. Their power, critically, was almost always indirect and extra-legal. It was derived from their status as wives or mothers of kings, from their personal charisma, strategic acumen, and ability to manipulate male figures around them, rather than from any formal legal right to rule or hold public office. They operated within the cracks of a male-dominated system, often through patronage, cunning, and sheer force of personality, and their power was frequently contested, leading to bloody conflicts and accusations of overstepping their natural bounds. The very controversies surrounding queens like Brunhild, who faced accusations of tyranny and usurping male authority, highlight the precarious nature of their influence. While they were incredibly powerful, their power was not institutionalized or legally recognized as inherent. It was a projection of their male relatives' authority, or a temporary necessity during periods of weakness, rather than a legitimate claim to political power in their own right. The fact that their influence often led to bitter power struggles and even their eventual downfall, Brunhild met a horrific end, proves the societal resistance to women holding direct political authority. In summary, while the occasional, exceptional queen might exert immense influence through informal means, the overarching legal and social structure of Frankish society in 588 firmly denied women any direct access to public office. Their exclusion from these spheres reinforced their legal subordination, positioning them as subjects of governance rather than participants in it, in a world where power was inextricably linked to masculinity. Number 2. Physical protection and the idea of property. Imagine a society where laws protect your physical person, but the underlying reason for that protection is often framed in terms of damage to someone else's property or honor, rather than your own bodily autonomy. For Frankish women in 580, laws concerning physical harm, including violence and even rape, operated within this peculiar framework. While women were certainly afforded legal protection from assault and injury, the way these protections were articulated and the way legal recourse was pursued often reduced the woman to a valuable asset whose violation was a wrong against her male guardian or family, rather than an independent individual. The Lex Salica and other Frankish legal codes meticulously detailed fines, or wergilds, for various forms of physical harm. These included injuries ranging from a simple bruise to permanent disfigurement, and even homicide. When a woman was physically assaulted, a specific wergild was prescribed for the perpetrator. However, this payment was not made directly to the woman. Instead, it was paid to her mundium holder, her father, husband, or guardian. This mechanism underscored the idea that the harm inflicted upon the woman was primarily a trespass against the man who held authority over her, a violation of his control and honor, and a reduction in the value of his property. The woman herself was the victim of the physical act, but the legal recompense flowed to her male protector, reinforcing her lack of independent legal standing even in matters concerning her own body. Consider a situation where a woman is assaulted. The legal process to seek redress would not begin with her own complaint to the court. Instead, her mundium holder would be the one to bring the accusation, present the evidence, and ultimately receive the compensation. This wasn't just a procedural detail. It reflected a societal view that a woman's body was, in a sense, part of her guardian's patrimony or property, and an injury to her was a quantifiable loss to him. This might seem cold or detached from a modern perspective, but in the Frankish world it was the logical extension of the mundium system. Crime of rape also illustrates this property-based legal framework. While undoubtedly a horrific experience for the victim, Frankish laws regarding rape often focused on the violation of a male's honor or proprietary rights, rather than the woman's bodily autonomy and consent. The lex selica, for example, prescribed fines for the abduction of a woman, especially if she was married, viewing it as a theft or violation of her husband's legitimate claims. Penalties might be higher for a woman who was already married, as it also implicated the husband's legitimate heirs. The focus of the legal action would often be on the compensation to the woman's guardian or husband, rather than a direct acknowledgement of the profound personal trauma endured by the woman herself. While the victim's testimony was important, the legal framework often placed the crime within the context of property infringement. Domestic violence, while perhaps not as explicitly codified with specific word guilds for internal family disputes, was also largely left to the discretion of the male head of the household. A husband's authority over his wife was vast, and societal norms often permitted him to discipline her, sometimes including physical chastisement. While extreme brutality might draw intervention from her birth family, the legal system largely viewed the internal workings of the household as the husband's domain. There were no specific laws or easily accessible legal avenues for a woman to independently seek protection from her husband's violence, further cementing her physical vulnerability within her own home. Her security was dependent on her husband's benevolence or the willingness of her birth family to intervene, rather than on independent legal rights. In essence, while Frankish law certainly recognized the harm of physical violence against women and provided mechanisms for redress, these mechanisms were deeply embedded in a system that viewed women as belonging to or being under the control of men. Payment of vergilds to male guardians, the framing of rape as a violation of male honor or property, and the limited recourse for domestic violence all highlight how a woman's physical protection was intrinsically linked to her subordinate status. She was protected not primarily as an autonomous individual, with inherent rights over her body, but as a valuable part of a male household whose integrity and value needed to be safeguarded for the benefit of her male protector. Number 1. Vocation and strictly defined social roles. Imagine a world where your entire life's path, from the moment you are born until you draw your last breath, is largely predetermined by your gender. For Frankish women in 580, and this was a deeply ingrained reality. Their vocational and social roles were rigorously defined, predominantly confined to the domestic sphere, agricultural labor, and reproductive functions with extremely limited opportunities. This strict demarcation of roles was not merely a custom. It was a fundamental aspect of their legal and societal subordination, reinforcing the patriarchal structure that governed every facet of Frankish life. Primary domain for Frankish women, regardless of social status, was the household. For peasant women, this meant an arduous life of managing the home, preparing food, spinning and weaving textiles to make clothing, raising children, and actively participating in agricultural labor. They would work alongside men in the fields, sow seeds, harvest crops, care for livestock, and manage dairy production. Their contribution to the household economy was immense and indispensable. Yet this labor was largely considered part of their domestic duty and did not translate into independent economic power or legal standing. Their work was essential for survival, but it rarely brought them outside the immediate control of the male head of the family. For women of the aristocracy, the household was a far grander affair, often a complex administrative unit. Noblewomen managed large estates, oversaw numerous servants, directed the education of their children, and supervised the production of goods necessary for a large household. They might even play a role in diplomacy through marital alliances, or influence their husbands and sons behind the scenes. However, even these powerful aristocratic women were fundamentally operating within the domestic sphere. Their administrative talents were applied to managing their husband's or father's property, and their influence was indirect, aimed at supporting the male lineage rather than exercising independent authority in the public or economic realms. Their vocation was that of a noble wife and mother, ensuring the continuation of their husband's family and the prosperity of his estate. Beyond the home and the fields, opportunities for women were scarce to non-existent. Formal education, in the sense of literacy and access to scholarly texts, was largely reserved for men, primarily those destined for the church or high administrative roles. While some elite women might receive basic literacy training, often within monastic settings, the idea of widespread female education for its own sake, or to enable careers outside the home, was alien. Craft production, like blacksmithing or carpentry, was male-dominated. While women might assist in certain trades, such as textile production or pottery, their involvement was typically as helpers within a family enterprise, not as independent masters or artisans with their own guilds or workshops. They could not own businesses, manage large commercial ventures independently, or participate in the burgeoning long-distance trade that was slowly developing. One of the few avenues for women to gain a different kind of life, particularly for aristocratic women, was the church, specifically monasticism. Entering a convent offered some women a unique path to intellectual development, spiritual authority, and even administrative power as abbesses. Figures like Radegund, a former queen who founded a monastery, show that convents could be centers of learning, piety, and even political influence. However, even in this context, the women were often removed from direct engagement with secular society and its legal frameworks. Monastic life represented an alternative to the mainstream societal roles rather than an integration within them. It offered a kind of spiritual autonomy, but it also meant renouncing the traditional roles of wife and mother, and it was primarily accessible to women from wealthy families who could afford to dedicate their daughters to religious life. The emphasis on women's reproductive role was paramount and deeply intertwined with their social function. A woman's value was significantly tied to her ability to bear healthy children, particularly sons, who would carry on the family name, inherit property, and perform military service. Barrenness could be grounds for divorce, and women who failed to produce heirs often faced social stigma or even repudiation. This focus on procreation further narrowed a woman's perceived purpose, reducing her to a vessel for the continuation of the male line rather than an individual with diverse potentials. In conclusion, the strictly defined vocational and social roles of Frankish women in 580 were not accidental. They were a deliberate and reinforcing aspect of their legal subordination. Confined largely to the domestic and reproductive spheres, with limited access to education, independent economic activity, or public life, women were systematically prevented from developing autonomy or wielding power outside the patriarchal structures of the family and the church. Their contributions were vital, but their status was defined by their relationship to men, making them indispensable within their roles, but perpetually subordinate in society.